A sitting judge who liquidates her own professional standing to provide a 5-minute regulatory shelter for a criminal defendant is no longer an auditor of the law. She is a systemic liability that has officially defaulted on her fiduciary duty.
A federal judge denied former Milwaukee County Circuit Court Judge Hannah Dugan's request to undo her conviction or grant her a new trial. In December, a jury found her guilty of obstructing an immigration arrest outside her courtroom. Now, Dugan claims she was immune from the prosecution and that agents did not have a lawful right to make an arrest in the courthouse. In his ruling, U.S. District Court Judge Lynn Edelman wrote Dugan's statement that she should take the heat for her actions and that she was in the doghouse with the chief judge for trying to help that guy being arrested, quote, suggests that she knew her actions were not on behalf of the court. Judge Edelman also wrote, when reviewing a challenge to the sufficiency of the evidence, the court will neither re-weigh the evidence nor second-guess the jury's credibility determinations. Dugan faces up to 5 years in prison. Sentencing has not been set.
I'm Camilo Motato, and this is Camilo's House. As a certified public accountant focused on forensic verification, I don't look at the bench as a throne of power. I look at it as a control center for the sovereign ledger of justice. In a standard financial audit, if a compliance officer is found physically assisting a high-risk account to bypass a regulatory seizure by ICE, you don't just issue a warning. You perform an immediate liquidation of their authority. Today, we are performing a judicial default reconciliation on former Judge Hannah Dugan. We are analyzing a scenario where the audit trail of her own statements proves she was in the doghouse with the chief judge, providing the forensic evidence necessary to uphold her felony conviction.
Immediately Thursday night, they said they'd fight the guilty verdict, and they're laying the groundwork to do so. Judge Edelman setting a briefing schedule and not a sentencing date. Biskubic with us shortly after. You talked about that last night, immediately saying we're going to fight this, so to speak. And these first motions, correct me if I'm wrong, will kind of ask Judge Edelman to set aside the jury's guilty verdict. How do you prepare that argument, and what is that going to look like?
Yeah, I mean, obviously lawyers want to raise whatever appropriate legal arguments and challenges can be made. And I know a lot of time the public is like, what's this? It's just this, technicalities, but obviously, I think it was Justice Scalia said one man's technicality is another man's fundamental constitutional right. And so the idea is, how do these rights get impacted by the verdict, but also how the evidence played out. And so the jury in count one, were asked, does she have to know that this specific person is being helped? And the answer was yes, and they found it not guilty. And then in count two, so the exact same conduct, the answer is put differently. No, you don't have to know that fact. And she's found guilty of count two. And of course, count two was the more serious of the two charges.
This is the moment where the law finally audited the auditor, and the resulting liability could be up to 5 years in a federal facility. The operational breach at the center of this saga occurred in a Milwaukee courtroom, where the internal controls for federal-state coordination were systemically overridden. Hannah Dugan didn't just misinterpret the rules. She performed a physical intervention to prevent a legal asset transfer, the arrest of a defendant named Flores Ruiz by ICE agents. From an investigative standpoint, this was a material breach of her operating agreement as a circuit court judge. While federal agents were stationed outside to execute a warrant on a man facing battery charges, Dugan was busy redacting the presence of federal authority by ushering the defendant out of a side door. It was a 5-minute shelter that resulted in a lifetime professional impairment. By attempting to provide regulatory asylum to a man who had allegedly defaulted on his social contract through violence, she devalued the integrity of her own bench to nearly zero. The forensic core of her recent appeal was a desperate attempt to claim judicial immunity. In auditing terms, this is a claim of total exemption from scrutiny. Dugan's legal team argued that she was acting within her official capacity and that the federal government had no jurisdictional standing to audit her actions in a state courthouse. But as a CPA, I track the scope of authority. No manager has the immunity to commit an off-balance sheet crime against a regulatory partner like ICE. U.S. District Judge Lynn Adelman's ruling, issued just yesterday on April 6, 2026, is a final audit report on this claim. He noted that Dugan's own disclosure, her statement that she was taking the heat and was in the doghouse with the chief judge, is documentary evidence that she knew her actions were not on behalf of the court. She was acting as a rogue agent, and in the world of forensic accounting, intent is the key metric for fraudulent activity. When the auditor admits they are in the doghouse for their actions, they have self-certified their own non-compliance. We must also audit the material conflict in the jury's verdict, the technicality that Dugan's team tried to use to refinance her freedom. During the original trial, the reporting standard for the two charges against her was inconsistent, which led to a split verdict narrative. For the misdemeanor charge, the judge told the jury they needed specific proof that she knew exactly who she was helping. The jury returned a not guilty verdict on that line item. But for the felony account, the more serious charge of obstruction, the instruction was broader. She didn't need to have a specific person in mind. She just needed the general intent to obstruct a regulatory action. The jury certified that felony conviction. Dugan's audit strategy was to blame the auditor, Judge Edelman, claiming that the instruction variance was a material error that impaired the jury's decision-making process. This strategy of blame is a high-risk maneuver that is ultimately defaulted. Dugan's attorneys argued that, but for the judge's mistake, she would have been liquidated of all charges. As an auditor of conduct, I find this management response to be reputationally insolvent. By blaming the bench for her guilty verdict, she was essentially asking the judge to admit to a systemic failure in his own management of the court. Judge Adelman's reconciliation was swift. He refused to reweigh the evidence or second-guess the jury's credibility determinations. The verification is now final. The instruction split was a procedural nuance, but the physical fact remains that a judge used her sovereign power to falsify a path to freedom for a criminal defendant. The technicality ledger has been closed, and the only open account left is the sentencing date. The social equity of this case is currently being amortized over the entire Wisconsin judicial system. Hannah Dugan threw it all away for a 5-minute political statement. As a CPA, I track the opportunity cost of credibility. To reach the bench, a professional asset must invest decades of ethical capital and compliance training. Dugan liquidated that entire portfolio to satisfy an ideological impulse. While the migrant asset, Flores Ruiz, was deported to Mexico and remains free in his home market, the manager, Dugan, is facing 5 years in federal prison. This is an asymmetric loss. The person she helped has no residual liability in this case, while she has inherited a permanent felony debt that will impair her earning potential, professional status, and right to vote for the rest of her life. My forensic verdict on the Judge Hannah Dugan audit is that we are witnessing the mandatory liquidation of a rogue management culture. The judicial system cannot balance its books if its auditors are colluding with the liabilities. The denial of a new trial is the final reconciliation of her guilt. She claims she was immune, but in a constitutional audit, no one is exempt from data verification. The doghouse statement was the smoking gun that proved her mens rea, the mental state of someone who knows they are overriding the system. Sentencing is the next scheduled payment, and the market of public opinion is waiting to see if the penalty will be amortized over a full 5-year prison term or written off as a slap on the wrist for a former partner in the legal system. I want to hear from you. Is 5 years a fair settlement for a judge who liquidated her integrity? Or is the loss of her bench a sufficient write-down of the damage? Does her in the doghouse disclosure prove systemic corruption in the courtroom? Or was she just a manager trying to protect the dignity of her branch? Let me know in the comments. Your perspective is the only audit that matters when the integrity of the bench and the sovereignty of the law are sitting on the negotiation table. I am Camilo Motado, and this is Camilo's House. Subscribe to stay informed on the numbers, the laws, and the truth behind the headlines. Stay safe.